Once parties have agreed to participate in arbitration, the procedure that they have to follow is actually really straightforward. Ultimately, it's a matter of contacting the clerks, which their respective solicitors would normally do, and they would negotiate in relation to fees, which are always fixed, and then they would also want to know the availability of those within chambers who could conduct the arbitration.
The forms that need to be filled out in relation to arbitration are very straightforward. In a children arbitration, the form ARB1CS has to be filled out. In a financial arbitration, it is form ARB1FS. Those forms are readily available on the internet. You simply enter in the search engine the name of the document and you'll find it. When you've filled out the document, you then send it to the Institute of Family Law Arbitrators, referred to as IFLA, and they will then send it on to the arbitrator. However, for solicitors, it may be more straightforward and indeed quicker if they send the form directly to the arbitrator if the arbitrator has already been identified.
When the arbitrator receives the form ARB1, the arbitrator will consider the form, look at the issues and set up a remote Teams meeting, usually just for the solicitors and the arbitrator, to make sure that the arbitrator is happy to accept the appointment. Afterwards, when the arbitrator has finished that, the arbitrator will accept the appointment and set up the directions hearing involving the parties. The directions hearing is just like a directions hearing at court. They will talk about the progression of the case and also expert evidence, etc. After that, everybody attends the arbitration final hearing, where we hear evidence from the parties, submissions, just like a normal court hearing.
The final arbitration is just like a final hearing in court. The parties may be represented or they don't have to be. There may be opening and closing submissions or written submissions. The parties will give evidence and be cross-examined, and the arbitrator would give a written decision. The arbitrator would apply the laws of England and Wales just like a court would.
We do have reports in arbitrations just the same as you would in the court system. CAFCAS don't get involved, so in welfare cases involving children, you wouldn't have welfare reports, but we can have independent social workers, we can have all sorts of professionals, psychologists. Again, that's something that can be agreed. It's usually done at the discussion stages at the first hearing when we're looking at who's going to be involved and the timetables for those. We hope that people can agree, but again, the arbitrator has the final say and they can appoint who the expert is going to be. And the same again if you're dealing with financial proceedings, that you can have various pension experts and other reports involved in it. So there's no loss, no difference there in between the two systems.
We think that given the pressures on the family court, family arbitration can provide a particularly important service to the family law community. As a judge, you only have a limited amount of time to read your papers. You may have many other cases in your list. As an arbitrator, you will only have one case in your list on a given day, and you can take as much time as you want to prepare it. You can also communicate directly with the solicitors to ensure that the case is ready. After the case has been heard, the arbitrator can take as long as the arbitrator needs to prepare a full and written judgment explaining the decision that has been reached. At the end of an arbitration, the arbitrator will give a full written decision explaining the outcome, just as a judge will give a judgment at the end of a court case. If a person is dissatisfied with the outcome of an arbitration, he or she may challenge it by applying to the family court. In the event of a challenge of that nature, the court would apply the same principles as it would on an appeal. So the person seeking to challenge the arbitration would have to show that there was a realistic prospect of success in that challenge before it would be allowed to continue. Statistically, the pressure on the family court is demonstrated, I think, by these figures. In 2013, there were 79,000 new private law and financial remedy applications in the family court. 10 years later, there were 95,000 new financial remedy and private law cases issued in 2023. That's an increase of 16,000 new cases a year over 10 years. Quite simply, if that increase were to continue for the next 10 years, everyone who has any experience of the family court can imagine what will happen. It won't cope. The pressure in the family court in private law cases is well known to magistrates who hear 46% of private law cases. Private law cases as a whole are taking an average of 42 weeks to come before the court. For that average figure to be achieved, it means that the contested cases are taking significantly longer than 42 weeks. For many private law cases, settle in the early weeks of the litigation.
The time that an arbitration procedure takes depends on the issues in the case. It is for a children arbitration, it can be on average about 10 weeks from start to finish. With financial remedies, it's more difficult to give an average because of the timeline for evidence, etc. But it will definitely, in both cases, be shorter than a court procedure.
Delay is very rarely in the interests of anybody. It causes emotional harm, an increase in costs, an increase in the stress. Parties become more entrenched in their views, and therefore it becomes more difficult to resolve matters. Parties can't be forced to engage in arbitration, but a party that unreasonably refuses to engage in non-court dispute resolution, such as arbitration, may well be at the mercy of a successful application for costs. The court has the power to adjourn court proceedings in order for the parties to engage in arbitration, so a plan based on delay may well be defeated in any event.
So if the arbitrator decides against your client, you're going to be worried if you get the blame. That's no different from the court system. In both scenarios, you're going to have an independent person making a decision about your case. The difference essentially is that you either agree as the two parties as to who that arbitrator is going to be, or IFLA will provide a specific arbitrator. But at the end of the day, if you've got concerns, speak to IFLA about it.
One of the advantages of arbitration, and there are many, is the cost element, because unlike court, it's always economically more viable. People often ask me, well, how can it be? And the main reason for that is it's a much quicker process. Costs are often shared between the respective parties, but not necessarily. It depends what they agree to do between themselves. But ultimately, costs are always going to be more efficient and less costly than going to court.